When the men writing the Constitution met in Philadelphia, some were worried that this might be their only chance to form a new government. So, they were very careful with the words they chose. You will see that in this segment as we look at the Preamble to the Constitution. This will help us answer the lesson question, which governing principles are identified in the Constitution? The U.S. Constitution creates our nation's government. It has three parts: the Preamble, the Articles, and the Amendments. Let's begin by looking at the Preamble. A preamble is an introduction to a document. The word literally means walking before. So, before the Constitution sets out the articles that describe the government, the writers wanted to walk the people through the ideas they hoped to address. The preamble explains where the legal power in the Constitution comes from and what the Constitution's most important principles are. The preamble is not that long, only 52 words. Let's take a look at them. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Whew, that's a lot to pack into 52 words. Let's start to unpack it by describing the predicate, or main clause of the sentence. We do ordain and establish this Constitution, this document. To ordain means to order something to happen. Here, the writers are legally ordering the creation of the Constitution. What do you suppose gave them the legal authority to order this?
The men who wrote and signed the Constitution believed in an Enlightenment idea called popular sovereignty. This is the belief that government is created by the people and government exists to serve the people. Many governments in Europe at that time were monarchies that believed they were picked by a divine power to rule. The Constitution was meant to upend that belief. Now, many Americans believe that the phrase "we the people" means we all of the people. The men who wrote the Constitution did not believe that popular sovereignty included everyone.
The preamble describes 6 reasons for the creation of the Constitution. The first is to form a more perfect union. What do you think the men who wrote the Constitution meant by that phrase? Remember, at the time, the United States operated under the Articles of Confederation. These articles had many flaws. Forming a more perfect union was meant to show that the writers saw these flaws and they hoped to fix them. They wanted to improve on the Articles of Confederation and to create closer ties between the states. The next 4 reasons were closely tied to these flaws.
Establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare. 4 ideas are listed here. All 4 ideas are connected to how the government should protect its citizens. Establish justice means to create a system of laws. When laws are easily understood and apply to everyone equally, this creates a sense of justice. People believe that the government is being fair. Enforcing laws is an important part of ensuring domestic tranquility, which means keeping the peace inside the country. What else does the government do to keep the peace? Are these actions always fair? The preamble also states that the government should provide for the common defense. Under the Articles of Confederation, it was unclear that the United States as a whole could defend its borders from outside threats. Individual states were expected to form state militias. The Constitution changed this. The preamble also says the government should promote the general welfare. This means that the government should help provide for the needs of the people it represents. Finally, The preamble describes one more reason for creating the Constitution: to secure the blessings of liberty to ourselves and our posterity. The word posterity means future generations of people. The men who wrote the Constitution wanted the government to protect freedom and rights for themselves and for future generations. Did they mean for those freedoms and rights to be extended to women and to Black and Indigenous people? Or to people from Asia or Eastern Europe? Maybe not. There's no way they could have known how the world would change and become what it is today. Now, let's check your understanding of the preamble of the Constitution.
In the first segment, we learned how the preamble of the Constitution establishes the idea of popular sovereignty and describes some of the responsibilities of government. We also discussed how these ideas did not apply to everyone when the Constitution was written more than 200 years ago. In this segment, we will learn about some of the principles incorporated in the Constitution. This will help us answer the lesson question: which governing principles are identified in the Constitution? The 7 articles of the Constitution create a framework for the government. Articles 1 through 3 describe the branches of government. Article 1 establishes the legislative branch. It outlines a Congress made up of a House of Representatives and Senate. Article 2 establishes the executive branch of government. It is made up of a nationally elected president and federal agencies. Article 3 establishes the judicial branch of government. This is the federal court system and judges. Articles 4 through 7 describe the duties and procedures for the government. Article 4 is about the states. It defines state and federal roles. Article 5 is about amendments. It describes procedures for changes to the Constitution. You will learn more about specific amendments as you move through the course. Article 6 states that the Constitution is the supreme law of the land, and it requires leaders to take an oath to defend the Constitution. Article 7 describes the ratification or passing of the Constitution. Delegates each signed the Constitution in Article 7. We saw that the preamble established a government by the people and the idea of popular sovereignty. The articles also establish the rule of law, federalism, separation of powers, and a system of checks and balances. Let's explore each of these foundational principles more.
The Constitution is the supreme law of the U.S. It regulates government powers. Under this principle, laws come from the people. The government can do only what the people give it power to do. Laws must also be enforced equally for all groups and people. Do you think everyone in the U.S. is treated the same if they break a law? Do all people convicted of a crime receive similar punishments? According to the Constitution's ideals, all laws should be enforced equally. This means that the people in government, those making and enforcing laws, are not above the law. Throughout history, hundreds of elected officials, including judges, members of Congress, and governors, have been charged, convicted, and sent to prison for various crimes. In this photo from 1973, U.S. Vice President Spiro Agnew announces his resignation after being charged with tax evasion. As governor of Maryland, Agnew illegally received payments from companies wanting to do business in the state. He was fined $10,000 and put on 3 years probation.
The Constitution created a nation with a central government that unites the states through the principle of federalism. Federalism is a way to organize and unite separate states into one country. Under federalism, power is shared by states and a central government, also called the federal government. There are national powers held by the federal government. These include having military forces, negotiating with other countries, regulating commerce between the states, and many other powers. State powers are often called reserved powers because they aren't listed specifically in the Constitution, which says that any powers not specifically given to the federal government are reserved for the states. This includes providing education and public safety and establishing local governments. Both the federal and local governments can collect taxes, build roads, and create court systems. Federalism limits both state and federal power. And even today, people do not agree on who should have more. Let's check what we have learned so far. One way the U.S. limits government power is through separation of powers. Separation of powers means government power is divided between the different branches. The Constitution created legislative, executive, and judicial branches. Each plays an important role in lawmaking. The legislative branch makes laws. The executive branch enforces laws, and the judicial branch interprets laws. Separation of powers limits the power of each branch because power is divided. For example, the legislative branch makes laws but cannot enforce the law or decide if a law is constitutional. The other branches do that. Power is also limited through a system of checks and balances. The Constitution created a system of checks and balances. This system made sure no branch had too much power. Let's look at a few examples. The executive branch can veto or reject laws passed by the legislative branch, and the president appoints or selects federal judges. These are checks on Congress and the judicial branch. Legislators can impeach executive or judicial officials. Officials can be impeached or removed from office for breaking the law. These are checks on the executive and judicial branches. The judicial branch can check the other two branches by deciding if laws passed by the legislature or actions by the executive branch are constitutional. Let's check out an example of checks and balances.
The judicial branch has a power known as judicial review. This power is a check on the legislative and executive branches of government. It's used to determine if the activity of the other two branches is consistent with the Constitution. With judicial review, courts can decide whether or not legislation is constitutional. Let's look at one example. In 1996, Congress passed legislation called the Defense of Marriage Act that outlawed same-sex marriages. A woman named Edith Windsor, who's shown here in this photo, filed a suit to overturn this law. She wanted the government to recognize her marriage to her wife. In 2013, the Supreme Court ruled that the law was unconstitutional because it violated the Equal Protection Clause. This part of the Constitution calls for all people to be treated equally under the law. This means that rights can't be given to one group of people, but denied to another group. The Equal Protection Clause has been used as a basis for overturning other kinds of laws too. With judicial review, courts also can determine if executive actions are constitutional or not. These are actions taken by the president, federal agencies, or other parts of the executive branch. Let's look at a 2008 Supreme Court case. A man from Algeria named Lakhdar Boumediene was being held at a detention camp called Guantanamo Bay. Although this prison is located in Cuba, it's run by the U.S. military. Boumediene and 5 other men had been taken into custody in 2002 because they were suspected of being terrorists. However, the U.S. had no evidence of a crime. Boumediene and the other men filed a lawsuit against President George W. Bush's administration to declare that they were being held illegally. This case was connected to a constitutional right known as the writ of habeas corpus. This protection gives detainees the right to petition a court to determine whether they've been imprisoned lawfully. Boumediene and the 5 other prisoners had not been allowed to file this request. The government argued that because the prisoners were not Americans, they did not have the rights of citizens at a facility that was not on U.S. soil. However, the Supreme Court decided that the men did have this right, and they were released soon after. Courts do not decide on their own which laws or executive actions to review. These decisions happen after individuals, organizations, or state or local governments file a court case to request that the judicial branch review a law or action that seems unfair or unconstitutional.
As we said, Article 5 established procedures for changing or amending the Constitution. There are currently 27 amendments to the Constitution. These amendments state freedoms and rights and establish procedures. For example, the 12th Amendment establishes the Electoral College to select the president. About a year after the Constitution was ratified, the new Congress approved the Bill of Rights. These first 10 amendments shaped the Constitution and added what many considered a guarantee or promise of certain specific rights. Among the political rights were freedom of speech, freedom of religion, and the right to assemble or get together with other people to form groups. Other rights included guarantees for people accused of crimes. These included the right to a writ of habeas corpus. This is the right to be brought before a judge and officially charged. Under British rule, it was common for people to be arrested and held in jail for long periods without ever being charged with the crime. The Bill of Rights also guaranteed people the right to a trial by a jury of their peers. Like many other parts of the Constitution, these rights were not applied to everyone equally when they were written. For some Americans, it took more than 150 years of struggle to benefit from the rights given more freely to others. Next, we will review what we've learned about the principles identified in the Constitution.